You're an artist. You have talent, material, and ambition. But what you don't have yet is someone in your corner to help you build your career. So you hire a manager. The manager starts making introductions, advising you on strategy, connecting you with producers, labels, studios, and brands. They help you navigate opportunities and negotiate your career. Then the relationship changes. Maybe the artist becomes successful and the commissions become substantial. Maybe the relationship breaks down. Maybe a lawyer reviews an agreement and asks questions that change the entire conversation. Was this person really acting as a manager, or were they acting as an unlicensed talent agent? Under California law, that distinction matters. The issue is not just what the contract says, it's what the representative actually did. I'm Scott Hervey, partner with the law firm of Weintraub Tobin, and today I'm joined by my partner, Tara Sattler. We are going to talk about artists, managers, and attorneys and the legal rules governing talent representation on today's installment of The Briefing. Tara, welcome back to The Briefing. Good to have you.
Thanks for having me.
Okay, so today we're going to discuss the California Talent Agency Act, the distinction between agents and managers, the cases that shape this area of law, including Park versus Deftones. I actually knew David Park, and Marathon Entertainment versus Blasi, the ethical obligations of entertainment attorneys and the provisions that artists and representatives should carefully negotiate in management agreements.
Great, let's jump in.
Okay, great. Okay, the most important concept is procurement. Under California's Talent Agency Act, a person who engages in the occupation of procuring, offering, promising, or attempting to procure employment or engagements for artists must be licensed.
Yeah, and that doesn't mean agents only procure. Agents negotiate contracts, advise clients, package opportunities, and advocate for talent. But procurement is the regulated activity. Managers generally focus on career development, strategy, branding, introductions, advice, and helping an artist build a sustainable career.
Right. The difficulty is that entertainment relationships are fluid. A manager may say, I introduced my client to the producer. That may be perfectly acceptable. But if the manager is the person calling the producer, pitching the client for the role, negotiating the engagement, and obtaining the opportunity, the labor commissioner may view that activity differently. All right. Let's talk about Park versus Deftones. That's a real important case. So the lesson from Park is that courts and the labor commissioner look beyond the title on the agreement. Calling someone a personal manager does not prevent scrutiny of whether that person actually engaged in procurement.
Imagine this hypothetical. A band's manager said, I'm just helping with career development. But the manager is contacting venues, negotiating performance opportunities, and securing tour dates without involving a licensed agent.
Right. That conduct begins to look much more like talent agency activity. The practical lesson is simple. The parties' labels do not control. The actual conduct itself controls. All right. The most significant California Supreme Court case decision in this area is Marathon Entertainment versus Blasi. That case involved actress Rosa Blasi and her management company, Marathon Entertainment. So Blasi argued that Marathon had engaged in unlicensed talent agency activity and that the management agreement should be invalidated.
So before Marathon, the Talent Agency Act was often viewed as a powerful weapon for artists seeking to escape management agreements. If a manager had engaged in procurement without a license, the artist could argue that the entire agreement was void. The California Supreme Court rejected an automatic forfeiture approach. Instead, the court focused on severability and whether the illegal conduct could be separated from the lawful portions of the agreement. The analysis requires looking at the nature of the violation and the extent of the procurement activity and the circumstances of the relationship.
Right. A hypothetical illustrates the distinction. Suppose a manager spends 95% of their time advising an artist on branding, touring strategy, and business development, but occasionally reaches out to a label executive about an opportunity. That situation is very different from a manager whose primary function is obtaining employment opportunities. The takeaway from Marathon is that not every instance of procurement activity automatically destroys the management agreement, but managers still need to understand the risk because crossing the line can create significant disputes over commissions and enforceability of their agreements.
So, New York approaches the issue differently. Employment agencies are regulated under New York law, but courts have recognized that personal managers may engage in some employment related activity when that activity is incidental to the broader management relationship. The important point is that managers operating across jurisdictions need to understand that the rules are not identical everywhere.
Right. So let's talk about entertainment attorneys and conflicts. So, entertainment attorneys face a separate set of obligations. California's current conflict rules require lawyers to analyze and disclose conflicts involving current clients and past clients. The entertainment industry creates unique conflict situations. I think unique's an understatement. A lawyer may represent a producer, a writer, an actor, an investor, or a company, all connected to one project or another.
Yeah, for example, an attorney represents a production company developing a television series and also represents a writer being hired for that series. Those interests may align initially, but they can diverge during negotiations.
Right. Or for that matter, a entertainment attorney represents a production company in one matter, but does not represent that production company in another matter. But you do represent a television writer or a director uh, negotiating with that production company on that other matter. That also creates a potential conflict situation. Also, imagine an attorney that receives an equity interest in a client's production company. That may create a separate conflict requiring careful disclosure and consent. The entertainment's lawyer role requires not just kind of deal expertise, but careful management of professional responsibilities.
Yeah, that's right. So let's talk for a minute about management agreements. They're often signed early in an artist's career, but the terms can have real long term consequences. Commission is the obvious issue. Managers often receive 15 to 20%, but the critical question is 20% of what?
Right. So the artist should examine whether commissions are based on gross income or some other metric, whether brand deals, endorsements, licensing, merchandising, and social media revenue, including AdSense, are included, whether commissions continue after termination and under what circumstances, whether renewals, extensions, sequels, spinoffs, and derivative projects are also covered. Term and termination rights also matter. A young actor may sign a 3-year agreement before obtaining meaningful work. If the relationship is not productive, the artist should have a clear exit mechanism. Power of attorney provisions, expense approvals, and ownership interest also deserve attention.
Yeah, and modern managers increasingly participate in producing, investing, and building businesses around talent. Those relationships can create additional disclosure and fiduciary issues.
Absolutely, 100%. Well, thanks again to my co-host, Tara. Always great to have your insights. And thank you to our listeners for joining us today on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave us a comment or a review and let us know what topics you would like us to cover. I'm Scott Hervey. I'll see you next time on the briefing.